Good morning, everyone. It is an honor for me to be part of this first panel of the second Michele Taruffo Girona's Evidence Week. I would like to welcome everyone to the cradle of evidence law in the world. And of course, we will start with this great event. I would really like to thank Professor Jordi Ferrer, Professor Carmen Vázquez, and everyone in the staff and the organization for the invitation and the honor to be part of this first panel.
Professor Michael Pardo. Professor Pardo joined the Georgetown faculty in 2020 and was named the Scott K. Ginsberg Professor of Evidence Law in 2024. His teaching and scholarship are in the areas of evidence, criminal procedure, civil procedure, philosophy of law and neuroscience. His current research focuses on philosophical issues pertaining to evidence, procedure, and legal proof. Professor Pardo was previously on the faculty at the University of Alabama School of Law, where he was the Henry Upson Sims Professor and a founder and co-director of the Law School's program on cross-disciplinary legal studies. He also served as chair of the Association of American Law School section on evidence. Professor Pardo's publications include 2 books, An Analytical Approach to Evidence and Minds, Brains, and Law, and more than 60 articles, essays, and book chapters. Professor Pardo, welcome. The word is yours.
Thank you very much for that introduction. Thank you very much to the organizers for inviting me to participate in this amazing conference. I am in awe of the breadth and depth of the topics and the wide array of impressive speakers from around the world. This is a large room. If I speak at this volume, can you hear me? Great, thank you. So I had the pleasure to meet and engage with Michele Taruffo at a conference here in Girona in 2011, and also to engage with him in print in a 2019 symposium in the International Journal of Evidence and Proof. I'm grateful for those opportunities and honored to give a lecture at the conference bearing his name. I'm also honored to be given the daunting task of giving the first lecture to begin this conference. My topic today is the relationship between legal epistemology on one hand and the process of legal proof on the other hand. By legal epistemology, I mean the use of philosophical concepts and ideas from epistemology, for example, knowledge, justification, warrant, safety, sensitivity, to illuminate aspects of legal evidence and proof. And by legal proof, I mean the formal process regulated by the law of evidence by which contested or disputed facts are considered to be proven for legal purposes. My discussion will be broad in scope and will try to sketch out some of the possibilities and some of the limitations with using epistemology or philosophy generally to understand the law. In order to ground the discussion, I will use work in legal epistemology by the late great philosopher Larry Loudon as an example, and I will then apply the lessons from that discussion to more recent work in legal epistemology. But first, I will begin by spelling out in some detail a picture of legal proof as I understand it, and some of the possible ways in which epistemology may illuminate that process. The discussion is not meant to be a comprehensive overview. In particular, I will aim to present one particular vision in which legal epistemology may be seen as continuous with evidence law and with evidence theory or theoretical accounts of the law more generally. In this vision, epistemology brings an additional set of conceptual tools and ideas alongside the tools from other academic disciplines that may help us to understand or better understand legal proof, and thus also perhaps to critique and improve it. 2 important caveats before I begin. First, my focus is exclusively on the ways in which epistemology may contribute to understanding law. I just described legal epistemology as continuous with evidence and evidence theory generally. This was a very loose reference to the philosopher W.V. Quine's notion of philosophy as continuous with science. Another apt methodological notion from Quine is the idea of reciprocal containment. He was talking about the relationship between epistemology and psychology in his picture of naturalized epistemology, with epistemology containing and making use of psychology and other empirical information, and psychology simultaneously studying and containing aspects of epistemology. I'm suggesting a similar kind of reciprocal containment between law and epistemology. The point is that there may be reasons internal to philosophy for philosophers to discuss law and legal examples that shed light on philosophical problems and ideas that do not necessarily shed much light on law. But that is not my focus. My focus is on what use, either pragmatic or theoretical, that these applications may have for law. Second, my focus will be on legal proof as it occurs in the United States. I am not a comparativist, but I hope my discussion of legal epistemology and legal proof in the United States will reveal some general lessons. Indeed, as I will emphasize, part of the challenge and a potential limitation with applying epistemology to legal proof is the risk of mismodeling or misdescribing the complex practices, rules, and doctrine that make up legal proof in particular jurisdictions. To illustrate this, I will often use standards of proof and the sufficiency of evidence in the United States as examples. And so my talk will have three main parts. First, I will sketch out the picture of legal proof as I understand it. Second, I will talk about the legal epistemology of Larry Loudon. And then third, I will talk about more recent work in legal epistemology. So part one, a picture of legal proof. By legal proof, I mean the formal process regulated by the law of evidence by which contested legal facts are considered to be proven or not for legal purposes. Legal proof has many component parts, practices, rules, and doctrines that vary across jurisdictions, but I will start with a simple picture. The presentation of evidence on one hand, in light of a burden and standard of proof on the other. In this picture, a fact has been proven when the probative value or the strength or quality of the evidence satisfies or surpasses the applicable standard of proof and has not been proven when it falls short of that standard. In the United States, there are three common standards of proof, each employed with relatively vague or ambiguous language. These include preponderance of the evidence, clear and convincing evidence, and beyond a reasonable doubt, the most demanding of the standards. And the standards apply to the elements of a civil cause of action, a crime, or an affirmative defense. And the basic policy idea is that the preponderance of the evidence standard aims to treat the parties roughly equally with regard to the risk of error by going with whatever side the evidence appears to support. You can think of a scale and kind of figuring out which way the evidence tips. With higher standards of proof, attempting to skew the risk of error in a particular direction by imposing a clear and convincing standard or a beyond a reasonable doubt standard. And so in this simple picture, we ask a fact finder, a jury or a judge, to decide whether, based on the admissible evidence, the disputed fact is proven to the standard of proof. Epistemology may help to enlighten several aspects of this simple picture. One, it may tell us something about the qualities of the evidence, its probative value. Two, it may tell us something about the standards of proof and what they require. Or three, it may tell us about how the two fit together and the reasoning that connects them. A helpful distinction that I employ sometimes is the distinction between micro-level analysis and macro-level analysis. Micro-level analysis looks at items of evidence individually, analyzing its relevance, probative value, and its overall strength, whereas macro-level analysis looks at whether there's proof of a case as a whole, whether the evidence meets a burden and standard of proof. Why is epistemology potentially a source of illumination or understanding? Because fact-finding could be better or worse epistemically. There are different kinds of decision-making errors that could be made in this process. Errors in assessing the relevance and probative value of evidence, errors in concluding whether or not the evidence as a whole meets the standard of proof, and ultimately errors in whether the facts that have been proven or not for legal purposes in fact match or correspond with reality. But in order to understand how these epistemic issues arise in a particular legal system, it is important to fill in some additional details. If the analysis is intended to shed light on or help us to understand that system. Focusing on the United States, one important issue in both civil and criminal cases is whether the evidence is sufficient or not, or adequate or not, in light of the standard of proof. And when I talk about the law in the United States, I'm oversimplifying to some extent. There's a difference between the law at the federal level and the law in the individual states, which may vary in various ways. I'll be focusing on the general federal level and some of the constitutional issues that apply more generally. So in assessing the sufficiency of evidence, as a matter of legal doctrine, courts in the United States generally ask whether a reasonable or a rational jury could, based on the evidence, find the disputed fact to the standard of proof. For example, could a reasonable jury in a civil contract lawsuit find for the plaintiff by a preponderance of the evidence? Or in a criminal case, could a reasonable jury find for the prosecution beyond a reasonable doubt? If a reasonable jury could not find for a party, in other words, must find for one party given the evidence and the standard of proof, that will typically end the case. One exception is acquittals in criminal cases which are not subject to sufficiency review because of constitutional considerations in the United States. These assessments of the evidence by judges are critically important pre-trial, during trial, and post-trial. They may decide whether a case gets to trial in the first place, whether a trial goes to a jury for decision, or whether a jury verdict is allowed to stand or is overturned as a matter of law. Such decisions by judges on the sufficiency of evidence are essentially epistemic determinations, as are fact-finding decisions at trial. Sometimes the evidence is strong enough and sometimes not, given the standard of proof. These are also decisions about whether a contested fact is proven or not for legal purposes, and thus are an integral part of legal proof, as much or perhaps more so than fact-finding at trial. Moreover, in order to understand the proof process in the United States at both the trial level and sufficiency reviews by judges, it's important to understand that the process as a whole is structured around competing explanations offered by the parties within an adversarial system. According to the party presentation and master of the case principles, parties provide explanations, typically accounts of the disputed events, that purport to explain what happened in light of the evidence, and then evidence may be used to support or challenge these explanations. According to the relative plausibility theory that Ron Allen and I have defended, as a descriptive matter, we can best understand the standards of proof as providing explanatory thresholds within this process. The preponderance of the evidence standard essentially requires having the better or best explanation of the competing explanations, with higher standards of proof imposing higher thresholds. For example, a plausible defense explanation may raise a reasonable doubt, even if it's not better than the prosecution's. I've also shown in recent work, in an article titled "What Makes Evidence Sufficient," that judges evaluate the epistemic sufficiency of evidence in light of these similar explanatory considerations, asking something like, could a reasonable jury find the plaintiff's explanation better than the alternatives based on the evidence? It's important to notice three important details about this process. First, the threshold for epistemic sufficiency is a minimal one. Courts are imposing a minimal threshold, asking what a reasonable jury could find, not trying to find the optimal decision based upon the evidence or trying to maximize rationality in any meaningful sense. Second, the epistemic context is a permissive one. In cases with sufficient evidence that go to a jury, either outcome is epistemically permissible. In other words, the evidence is sufficient or adequate to support either finding. Third, the process is highly dependent on the adversarial system, not only to produce evidence, but also to provide the competing explanations for fact finders to choose between that will structure the process. Judges and juries can decide based on theories or explanations not advanced by the parties, but they're not required to do so. These are facts about legal proof in the United States and how it is structured. I've spent some time spelling them out in detail because, in my view, they've been neglected in recent epistemology discussing legal proof, which is focused primarily on fact-finding at trial and determining the epistemically correct outcome. Such a focus misses the broader context for when evidence is epistemically sufficient or not, and thus when facts are proven or not for legal purposes. Epistemology may provide normative reasons to critique the facts or practices that I've spelled out, but when it is being used to try to illuminate or help us understand aspects of legal proof, it risks mismodeling the object of inquiry by missing this broader context. So my plan now is to turn from this picture of legal proof in the United States to talk about legal epistemology, focusing first in detail on Larry Loudon, and then turning to more recent work. So part 2, the epistemology of Larry Loudon. After a distinguished career as a philosopher of science, Larry Loudon later in life turned to law and legal proof, illuminating and critiquing the evidentiary proof process in criminal cases with a particular focus on criminal law and standards of proof in the United States. Despite the implicit connections between evidence law, legal proof, and epistemology, when Loudon turned his attention to law, modern evidence scholarship had not made extensive use of modern work in epistemology. There were, of course, exceptions, going back at least to Jeremy Bentham, who wrote that the field of evidence is no other than the field of knowledge. But in his 2006 book, Truth, Error, in Criminal Law, an essay in legal epistemology, Loudon was able to write plausibly, quote, "Legal epistemology scarcely exists as a recognized field of inquiry." He set out to change that, and he was, in my view, partly responsible for the explosion in scholarly work on legal epistemology in recent years. He wasn't the only philosopher writing about evidence law at the time. Credit also goes to other philosophers such as Alvin Goldman, Judith Thompson, Jonathan Cohen, Susan Hack, Brian Leiter, Scott Brewer, Fred Schauer, and many others. But in my view, Loudon's work was critical in spurring some interest in legal philosophy. In her biography on the great legal philosopher H.L.A. Hart, Nicola Lacey quotes H.L.A. Hart as describing his own work as, quote, "selling a little philosophy to the lawyers." But as my colleague John Michele has documented, part of Hart's legacy was also selling a little law to the philosophers. We can say some of the same about Larry Loudon and legal epistemology. He both sold a little philosophy to the evidence scholars and sold a little evidence law to the philosophers. The explosion of work in legal epistemology in the past couple of decades by both evidence scholars and by philosophers is in part a testament to his legacy. It is thus no longer true, as Loudon wrote in his 2006 book, that, quote, "legal epistemology scarcely exists as a recognized field of inquiry." I will briefly mention some of Loudon's insights in legal epistemology and then focus on some limitations in his analysis for understanding legal proof based upon the picture that I outlined in the first part of my talk. I will then illustrate how my critique and similar limitations also arise in more recent philosophical work in this area. So important insights from Loudon's work include the following. First, Loudon argued that legal standards of proof should focus less on the subjective state of mind of the fact finder, such as doubt, belief, certainty, and should focus more on features of the evidence that would justify or warrant someone in holding that particular state of mind. This analysis usefully drew attention to the epistemic dimensions of legal proof. Second, in theorizing about errors in legal proof, Loudon explained and illustrated an important distinction between probatory errors and material errors. A fact finder might err in applying the standard of proof, for example, finding a defendant guilty beyond a reasonable doubt when the evidence does not warrant that conclusion. That would be a probatory error. Or you can err because a fact-finding decision does not in fact match reality, a material error. Loudon clarified that neither type of error implied the other, that you can have a probatory error without a material error, and you can have a material error without a probatory error. And he clarified, too, that evidence scholarship often confused the two. 3, he clarified and illuminated the presumption of innocence. He argued persuasively, in my opinion, that the presumption is best understood as a probatory, epistemic blank slate, and not as itself evidence, a presumption about material innocence or a prior probability of guilt. 4th, his work, some of which was co-authored with Ron Allen, usefully illustrated some of the costs associated with false acquittals in criminal cases, and also illustrated the conceptual limits of Blackstone ratios when trying to justify standards of proof. My critique today will focus on 2 aspects of Loudon's analysis of standards of proof in the United States, the legal system that was his primary focus. First, his analysis of standards of proof attempted to reduce and isolate features of the law that cannot be reduced and separated from the proof process as a whole. For example, Loudon argued both, 1, that the sole function of standards of proof should be to distribute fact-finding errors between the parties, and 2, that no other rules or practices should serve this function. This was a consistent theme in his analysis. It appeared in his 2006 book, in a 2015 essay that he presented here in Girona, and in his 2016 book, The Law's Flaws, Rethinking Trial and Errors. On the first part, he stated, quote, "The standard of proof is not an error-reducing device. Error reduction should be left to other evidence rules, such as admissibility rules." And that, quote, "The standard of proof functions solely, quote, to shift the errors that do occur in a particular direction." In my view, this is incorrect conceptually. Why? Because in addition to allocating the risk of error, standards of proof may also affect the total number of errors a system creates. For example, the preponderance of the evidence standard is thought, under certain conditions, to reduce the total errors or minimize the total number of errors, and thus raising a standard of proof may produce more overall errors. Why? Because verdicts might be more likely to be true given the evidence, but taken to be false by the law. On the second part, he argued that all error allocation should be funneled into the standard of proof, and therefore that all other evidence rules and practices that had some asymmetric effect, for example, that systematically favored one side, like the prosecution or the defense, should be eliminated. He referred to these as burden enhancers and burden reducers. This is an interesting philosophical exercise, but in my view, it's a kind of epistemic fantasy. It would be virtually impossible to eliminate every possible rule or practice that might systematically help one side more than the other. And the fact that many of these rules are US constitutional rights and well-established evidentiary privileges, this strikes me as a non-starter. There's an elegance to his analysis on this issue, but it seems more realistic and more helpful from an evidence scholar perspective to talk about the risk of error in the system as a whole, with standards of proof as one component. And this is because some of the other limitations with the analysis. So second, Loudon's analysis, in addition to being reductive in the way that I just explained, trying to reduce all error allocation into the standard of proof and nowhere else, also assumed a kind of precision for standards of proof that seems illusory at best and that ignored the explanatory structure of proof that I outlined at the beginning. He critiqued beyond a reasonable doubt for its imprecision and vague language. In its place, he never settled on a specific verbal formulation, but he argued that the standard should be informed by the various frequencies and harms associated with both false convictions and false acquittals. And then his analysis assumed that a precise criminal standard of proof could be constructed that would produce the desired ratio of errors. He used this analysis to argue that the beyond a reasonable doubt standard in the United States is too high and should be lowered. Other scholars have critiqued Loudon on this issue. I will mention two. Georgie Gardner, one of our other lecturers this week, provides an excellent critique of Loudon's use of empirical information on crime statistics. And Diego De Vecchi has an article that points to an internal tension between Loudon's claims that beyond a reasonable doubt, on one hand, is vague, arbitrary, and subjective, and yet on the other hand, the cause of false acquittals based on a rational connection to the evidence, that there's this internal tension in the presentation. My focus in this talk is on the inconsistency between this attempt at precision and the picture of legal proof in the United States that I started with. Loudon's analysis is inconsistent with the judge-jury relationship and the role that standards of proof play in evaluating the sufficiency of evidence, which is primarily an epistemic evaluation. The context, again, for sufficiency of evidence review is a minimal standard, one of epistemic permissibility within an adversarial system. But so what might be the response? His point was to change practices, not to explain them. Not exactly, in my view. Loudon was attempting to change specific aspects of legal proof in the United States. In this case, the standard of proof in criminal cases and some admissibility and procedural rules, while leaving the basic structural features of legal proof in place, including the jury trial and the judge-jury relationship. Here is the problem. A standard of proof can either be implemented with precision or not to produce the desired ratio of errors, say 8 false acquittals for every false conviction or whatever. And for Loudon, this meant implemented with precision based on the epistemic features of the evidence, not subjective beliefs or credences. If a judge can tell with precision whether the evidence meets the standard of proof, then there's really nothing left for a jury to do. The judge should just apply the standard and produce the desired result. The only possible reason to have a jury trial might be to preserve the jury's power in the United States to nullify or acquit despite the evidence satisfying the standard of proof. But if a judge can't ever tell whether a precise standard of proof is satisfied in a given case, which seems more plausible, then we're back to something like the current proof structure for evaluating the sufficiency of evidence, a context of epistemic permissibility in which either outcome is permitted, which involves a minimal threshold and is highly dependent on the adversarial system. But if this is so, then it's unclear how the system could ever produce a precise ratio of errors, even with a precise standard of proof. Relatedly, Loudon's analysis also failed to appreciate the explanatory structure of proof that I outlined earlier. Loudon was familiar with what is called inference to the best explanation in the philosophy of science, its features, and its critiques and limitations in that context, and indeed he was a major critic in the philosophy of science literature. He assumed, mistakenly in my view, that this idea would operate similarly in both contexts, in law and science, and so he critiqued the possibility that inference to the best explanation could shed light on legal proof in criminal cases. Since, for example, something might be the best explanation but not proven beyond a reasonable doubt, or not the best explanation but enough to raise a reasonable doubt. What this critique misses, however, is that the law can use and adapt similar ideas and concepts that are found in philosophy in ways that don't necessarily match their features in philosophy or science. In the United States, the explanatory thresholds for standards of proof, both at trial and in sufficiency of evidence review, do not match inference to the best explanation in other contexts. In particular, for higher standards of proof, the explanations must be stronger than just better than the alternatives. And correspondingly, a defense explanation in a criminal case may raise a reasonable doubt, even if it's not the best, so long as it's good enough to be plausible. The lesson here is that features of a concept or idea that might be challenges or worries in other philosophical contexts may not be problems when applied to the law. This also suggests that philosophical concepts and ideas might provide useful tools for illuminating or making explicit epistemic aspects of the law, even when they don't quite match their uses or their necessary features in other philosophical contexts. And to know whether they do so, you have to look closely at the details of a particular legal system. So from my discussion thus far, I see 3 specific lessons emerging and then a 4th meta-lesson for how epistemology may shed light on legal proof or how it may fail to do so. One lesson is the danger in trying to reduce or isolate features of legal proof that can't be reduced or isolated, such as allocating the risk of error. The second lesson is the illusion of precision. To think that some complex feature, rule, or practice, such as the standard of proof, can be given sharp boundaries when it can't. The third lesson is that a potential mismatch between philosophical concepts and how they arise in law is not necessarily a problem for law. And the fourth sort of meta lesson is the risk of mismodeling or misdescribing the legal phenomena that are the object of philosophical inquiry. So I will now, in part 3 of the discussion, turn to how some of these lessons apply to current work in legal epistemology, again, taking the perspective of an evidence scholar and asking, what does this illuminate or help us understand about legal proof in the United States? So in this section, time permitting, I will focus on 4 examples: statistical evidence, the preponderance of the evidence standard, epistemic safety, and the concept of knowledge. The first example concerns the vast and fast-growing literature by philosophers concerning statistical evidence and a distinction between statistical and non-statistical evidence. Much of this literature is framed around solving or explaining the so-called puzzle or paradox that arises in hypothetical cases or vignettes involving statistical evidence, such as the famous blue bus hypothetical, in which the blue bus company owns 70% of the buses in the town, and we're told that there's no other evidence other than a common assumption that a bus was responsible for an accident. The puzzle or paradox is supposed to arise from the fact that the statistic, 70%, appears to surpass the standard of proof, where the preponderance standard is assumed to mean greater than 50%. Yet the intuitions of most people is that the evidence is not sufficient to support liability. Much ink has been spilled, and I confess that I'm guilty of this as well, in trying to explain or explain away these hypotheticals. And to be fair to the philosophers, many of the famous hypotheticals were introduced into the literature by legal scholars. I also should apologize for introducing the blue bus hypothetical so early in the conference. As philosophically interesting as this literature is, it does not, in my view, shed much light on legal proof, at least in the United States. One reason, as Ron Allen and Christopher Smikeklas have shown, is that there is no general statistical, non-statistical evidence distinction in US case law. If there's a distinction, it's between reliable and unreliable evidence. So the object being explained or analyzed in the literature, which are basically intuitions about the hypotheticals, don't actually map onto legal reality. But even taking the hypotheticals at face value, there's no puzzle or paradox to be explained if my starting picture of legal proof is correct. And that picture helps us to diagnose why there is no puzzle or paradox. There is thought to be a puzzle or paradox because of the combination of 2 premises. One, that the statistic, 70%, is the probative value of the evidence, and 2, that the standard of proof is a probabilistic threshold of 50%. But if neither premise is true, then there is no puzzle or paradox. And neither premise is true in the picture that I presented. The standard of proof depends on the competing explanations, and probative value is determined by how it supports or challenges those explanations. Instead of puzzles or paradoxes, the hypotheticals are just unspecified cases without enough information about the case to decide one way or the other in terms of what to do. If so, this might explain why, despite all of the ink that has been spilled, there's no consensus on a solution to these issues. This literature, in my view, exhibits some of the limitations I mentioned earlier in the Loudon discussion. It's overly reductive in trying to capture something essential about statistical evidence. It relies on the illusion of precision, i.e. that probative value and standards of proof can be sharply defined, and it misses the explanatory structure of proof, mismodeling details about probative value and the standard of proof. This discussion may be philosophically valuable. In particular, it may help explain intuitions in ways that are similar to the lottery paradoxes in philosophy. but they don't tell us much about legal proof in the United States. Putting aside the specific issue of statistical evidence, the literature on legal epistemology has generated a number of other general interesting ideas about standards of proof and features of legal evidence. My second example concerns philosophical accounts of the preponderance of the evidence standard. Much of the philosophical literature on standards of proof, in my view, mismodels the object of inquiry by missing several of the features that I outlined earlier, including the explanatory structure of the proof process, the epistemically permissible manner in which courts assess sufficiency or adequacy of evidence, and the role of the parties in supplying the comparative explanations. I want to draw attention to two notable exceptions in the epistemology literature, though, by Sarah Moss and Georgie Gardner, respectively, which in my view come closer to accurately describing legal proof and are in different ways illuminating. Each does so in different ways by adapting a relevant alternatives framework from epistemology, which connects with the fact that legal proof is comparative in the sense that it depends on comparing alternative explanations of the disputed events. But both accounts, in my view, also fail to accurately capture some of the underlying important legal details. So the preponderance of the evidence standard, again, in theory, is meant to treat the parties roughly equally with regard to the risk of error by going with whatever side the evidence better supports. And in practice, fact-finders choose the better of the competing explanations advanced by the parties. Fact-finders may, but they need not, consider other alternatives. And courts review sufficiency of evidence by asking whether a reasonable jury could find plaintiff's explanation better than the alternatives advanced. According to Moss's knowledge account of legal proof, a fact is proven by a preponderance of the evidence when a fact finder has knowledge that the disputed fact is greater than 50% likely or greater than 0.5. In other words, the fact finder must know that the defendant is probably liable, not just believe or reasonably believe. What's wrong with this account of the preponderance standard? As a practical matter, it doesn't match what fact finders or courts do. The law may consider a fact proven by a preponderance of the evidence and the evidence sufficient to support that finding in the absence of such knowledge. And theoretically, such an account fails to treat the parties equally with regard to the risk of error. Moss's account, in other words, places too much risk on the party with the burden of proof, which may be not only parties in civil cases, but also criminal defendants trying to prove an affirmative defense, or all parties with regard to the admissibility of evidence, since the preponderance of the evidence standard also controls whether various admissibility rules are satisfied. In other words, a fact finder could think a party's explanation is better and thus more likely, and a judge could think this finding is reasonable, and the party still loses under the Moss account because the fact finder doesn't know that the probability of the disputed fact is greater than 0.5. In most cases, no one has any idea of the actual probability of the disputed fact conditioned on the evidence. Gardner's relevant alternatives account of the preponderance standard avoids some of these pitfalls. It doesn't require knowledge, and it doesn't require or quantify the preponderance standard. It requires that the party with the burden of proof produce sufficient evidence, quote, to rule out preponderant error possibilities. The alternative explanations that must be ruled out under this account are the ones that are, quote, most significant or most predominant. The most usual ways claims such as the one being made are false, as well as the ones a judge would most expect to see, and those a virtuous inquirer would think most important and that seem most weighty as potential doubts. Similar to the Moss account, this philosophical framing, in my view, essentially requires too much of parties with the burden of proof and consequently places too much of the risk of error on that party. Why? Because it requires that for a fact to be proven by a preponderance of the evidence, the fact finder must rule out alternative explanations beyond those advanced by the parties. First, in the United States, under the party presentation and master of the case principles, courts and fact finders are not required to consider alternative explanations and arguments not advanced by the parties. And second, when there is a choice to be made between plausible alternatives that are advanced by the parties, there's no necessary requirement that an alternative be ruled out, only that one could be found comparatively to be more plausible or better. Perhaps there are good normative reasons to prefer these conceptions of the preponderance standard, but in my view, they fail as descriptive accounts of the preponderance standard, at least as it is deployed in the United States. But I pick these examples because they come closer than most other counts of standards of proof in the philosophical literature. In particular, they capture some but not all of the explanatory structure of legal proof, but they miss the adversarial principles that drive legal proof in the United States, and in different ways allocate the risk of error in ways that deviate from the standard's underlying policy goal. My final examples discuss some ways in which epistemic concepts may illuminate aspects of legal proof, even when they diverge from their details and features in epistemology, similar to inference to the best explanation and standards of proof in the Loudon discussion. And I'll focus on two ideas, epistemic safety and the concept of knowledge. The third example concerns epistemic safety and sensitivity as tools to explain features of evidence. Much of this literature has focused on the statistical evidence debate that I discussed earlier. I want to put that aside for the reasons discussed and ask a different question. To what extent can either notion help explain micro-level features of evidence, such as probative value? In epistemology, these concepts are typically used to analyze true beliefs, starting with a true belief and asking whether the belief would continue to be held in various counterfactual scenarios or possible worlds in which the belief is false. Sensitivity asks something like, in the closest or similar possible scenarios in which something is false, would the person still believe it to be true? And safety asks something like, how easily could it be false and the person still believe it to be true? As with the discussion of Loudon and inference to the best explanation, here is an area where it is important to recognize that applications to legal proof will not quite match the uses and features of these concepts in other contexts. In law, we typically do not know whether a verdict or some piece of evidence, say a witness identification, is true or false, but we can ask instead, assuming it were true, would some evidence or an inference from that evidence be safe or sensitive? In philosophy, which possible worlds or which scenarios count as close or closest, etc., can be tricky and contested. But in legal proof, the possibilities at issue are, once again, the alternative explanations advanced by the parties, even if they wouldn't necessarily count as closest in philosophical analysis. With this framing in mind, I've argued that something like epistemic safety, even if it's not isomorphic with safety in epistemology, tells us something about the probative value of evidence. Here's why. Suppose we have an eyewitness to a crime who identifies a suspect's photo as the perpetrator. But suppose that that eyewitness would identify any photograph placed before him as the perpetrator. Even if we assume that in our scenario the identification happened to be true, the identification has low probative value as evidence, in part because it is unsafe. It could have so easily been false if the person were shown a photograph other than the perpetrator. As the philosopher John Greco explains, epistemic safety, quote, just is reliability through close counterfactual situations. And something like reliability through close counterfactual situations matters for legal evidence, particularly when the parties are arguing about which situation is true and which are the counterfactual. Incidentally, I've argued that sensitivity doesn't tell us as much about probative value because the closest possible world in which evidence or an inference is false may not be a close world. But sensitivity, however, does direct our attention to other important features of evidence, such as whether the evidence would exist in close possible scenarios in which the disputed fact was false. It may, for that reason, have important incentive effects, as Enoch, Fisher, and Spector have argued. In this example, something like safety helps to articulate some aspect of probative value, and it does so even if it doesn't match safety in epistemology. It might also do so even though there's more to probative value than safety. In other words, the concept might illuminate legal proof without being a necessary feature or without being a separate requirement or capturing all there is to probative value. To claim otherwise, as some philosophers have argued, is to again take too reductive an approach when applying epistemology to legal proof. My fourth and final example concerns the concept of knowledge itself. Knowledge is another example in which legal proof may share some features with knowledge, but lack other features. Despite this mismatch, it may help to illuminate aspects of legal proof. The traditional conception of knowledge as justified true belief has analogs when applied to legal verdicts. So we have these three conditions: true, justified, belief. But when we're talking about verdicts, we can talk about truth as a goal and aim. Just like beliefs, verdicts have some level of epistemic commitment involved. It may not be beliefs, it may be something like acceptance or acceptability, as Jordi Ferrar has argued. There's also some level of justification based upon the evidence. The level of justification may not be as strong enough as the level of justification for knowledge. And so we have features that look similar to knowledge in some ways, even if verdicts don't require beliefs and have a different level of justification. In epistemology, these conditions, these three conditions, justified true belief, may not be sufficient for knowledge if there's an accidental or coincidental gap between the justifying evidence on one hand and truth on the other hand. This was famously shown by Edmund Gettier and the famous literature now on Gettier cases. I've argued that a similar accidental connection may also undermine legal verdicts. For an extreme example, consider a defendant who's been framed by the police and they've falsified evidence, but also the defendant happens to be guilty and is convicted. There appears to be sufficient, although falsified evidence at trial to justify the conviction, and the verdict is true, but there's still a problem with the verdict. Drawing out the similarities between knowledge and legal proof helps to make explicit this aspect that might otherwise go unnoticed. That in addition to justifying evidence and truth, for a successful verdict, there has to be an appropriate connection between the evidence and truth. This sheds some light on legal proof. Notice that this insight applies even if successful verdicts do not constitute knowledge for other reasons having to do with, say, justification or belief. And so this is another example, like with inference to the best explanation, where a philosophical concept may illuminate aspects of legal proof even if it doesn't match its uses elsewhere. So to conclude, I've presented a complicated picture of the relationship between legal epistemology and legal proof, taking the position of an evidence scholar and asking how legal epistemology might help us better understand legal evidence and proof. From this perspective, I've discussed some general lessons in applying epistemology to law. One lesson is the danger in trying to reduce or isolate features of legal proof that can't be reduced or isolated. The second lesson is the illusion of precision, to think that some complex feature, rule, or practice, such as a standard of proof, can be given sharp boundaries when it can't. The third lesson is that a potential mismatch between philosophical concepts and how they arise in law is not necessarily a problem for law. I've also tried to draw attention to the risk of mismodeling or misdescribing the legal phenomena that are the object of epistemological inquiry. The picture that I've presented is not one of simply applying or deducing consequences or implications from a favored philosophical theory or concept. Rather, it involves close attention to the complicated details of the evidentiary proof process in a particular legal system. In applying epistemology to law, the picture that I have in mind may resemble in some ways something like the philosophy of physics, which involves both the combination of abstract philosophical tools and concepts on one hand, with detailed specialized knowledge of complex phenomena on the other hand. The complexities involved are also an invitation for more collaboration between philosophers and legal scholars about the details that matter from each discipline. I'll finish by returning to Larry Loudon. Loudon seemed to endorse a similar approach. Rather than apply a theory or theories from the philosophy of science, he grappled with the messy details of legal proof, criminal law, and criminal procedure in the United States, and tried to bring some clarity to what he observed. And conferences such as this one are exactly what his work encouraged. I'm grateful that I had the chance to know and to learn from him. I'm sorry he's not here to tell me all the ways that I'm wrong, but hopefully some of you will do so. Thank you.
Thank you, Professor Pardo. Muchas gracias. Bueno,
Thank you. So now we shall start the open discussion. We would like to remind you there's the option of asking questions and also raising your hand using the app. So let us start with the first question. I'll wait for the professor to put his headset on.
So epistemological notions such as justification, warrant, and the like seem to be detached from the practical concerns such as how do we want errors to be distributed according to their gravity. How then can epistemology be useful to illuminate legal standards of proof?
Can you repeat the question?
Sure. Epistemological notions such as justification, warrant, and others seem to be detached from practical concerns, such as how do we want errors to be distributed according to their gravity. How then can epistemology be useful to illuminate legal standards of proof?
So as I can you hear me? Okay. So as I understand it, there are kind of two issues. No, it's not on.
Yeah.
How about now?
Yeah.
Great, thank you. So as I understand the question, there are kind of two different things going on there. One is the connection between epistemic concepts and ideas and truth, or factual accuracy. I don't necessarily see a tension there. In fact, I think most of the discussion of epistemic ideas are in the service of truth. I think we think a justified verdict is more likely to be true than an unjustified verdict. And so I see many of the epistemic ideas as serving instrumental roles and connected to truth. So that's kind of the first issue, right? There does seem to be an epistemic relationship between the epistemic criteria and truth. I think an unsafe verdict is more likely to be false than a safe one, even if we put aside the truth issue. The second issue then is about allocating the risk of error. And here I think the distribution here makes a judgment about how justified or how strong the evidence has to be. And so it's making choices about sort of what to do when you've achieved a specific level of proof. Some of the ideas in epistemology might tell us something about whether the thresholds that are imposed by the standard of proof have been satisfied or not. But sort of where to set those thresholds may also involve other political choices about how to allocate the risk of error.
Thank you. Well, I have a question of mine. In 2015 essay, you describe how jurors are instructed to deliberate, to offer reasons, to keep an open mind. And you mentioned that those are some epistemic duties and obligations that the jury should perform, acting as you call a fiduciary, with characteristics similar to other fiduciary with other relationships, those of trust. In civil law countries, many authors now criticize the institution of the jury, considering it or them as irrational. Trust can be rational or irrational, as we all know, and I would like to comment of yours, saying, in your opinion, can our trust in the juries be considered rational? What happens if the jury decide not to comply with these obligations you describe?
My priors here, I'm pro-jury. I think juries can be rational. I think juries are often rational. In terms of giving reasons, we expect jurors to give reasons to each other and to deliberate. And an important thing to note about this connection between evidence and the standard of proof is that at least half the evidence is in the mind of the jurors. We ask jurors to bring their sort of common sense reasoning to bear on the evidence, and a group has the collective knowledge between them to sort of deliberate, so there's some advantages just from a group perspective. The check on the jury, as I mentioned, is a minimal one, so there's always the possibility of individual jurors going awry, but I think the empirical literature on juries sort of well supports the idea that jurors are competent and rational and do a good job. And so that's sort of my view, but others may disagree.
Thank you. Well, another question from the public. What is the speaker's opinion on Laudan's position on the philosophy of science? Do you think this could affect his positions on epistemology in law?
That's a great question. I haven't thought much about the connection. The one connection that I discussed is what I thought was the fact that he'd been a critic of inference to the best explanation, I think influenced his views on law in a way that I think he didn't appreciate the differences there. I like his work in the philosophy of science to the extent I understand it. I'm not an expert in the philosophy of science. I learned a lot from talking through ideas in the philosophy of science with him. I think there are other aspects of his writing in the philosophy of science that I do think could be mined for other insights in law. And so I would encourage scholars interested in that project to pursue that.
Thank you. Well, another question from the public. If I'm going too fast, you...
Oh, yeah, no, that's good. Rapid fire. Let's go.
We are finding the pace.
Yeah.
Well, is expected utility theory the only or preferred framework from which to draw the degree of severity of standards of proof?
I mean, my intuition is no. I think it can be a very helpful framework for thinking about the relative costs and benefits when thinking about trial outcomes. But I do think there are other procedural values that inform whether we have a successful and justified verdict, including the participation of various actors and other political values. And so I imagine an expected utility framework can try to incorporate those other values, but I'm not sure.
Thank you. Well, this one is about safety.
Okay.
Safety needs the belief being evaluated to be true in order to ask whether the inference was safe. But we almost never know with certainty, for example, that the accused committed the crime. Is safety really applicable or illuminating in the process of legal proof? This one is from the public.
Yeah. So I think to get some insight for law, I think you have to recognize that the idea or the concept that we're working with isn't exactly safety in epistemology if by that idea we mean we're kind of assuming truth. Right? We may not know whether it's true or not, and so we have to ask a slightly different question, which is, if it were true, right? If it were true in this instance, how easily could it have been false? And that, I think, tells us something, not everything, but it tells us something about the value of evidence. If you think through the example I gave, or you think through other possible examples, if you ask, even if we happen to get it right in this instance, if this evidence is consistent with lots of other close possibilities that point in the other direction, that may undermine the value of evidence. On the other hand, if it's safe in that sense, right, it's reliable through all these different counterfactual possibilities, that tells us that it's stronger evidence, right? If for it to be false, it couldn't easily have been false. Lots of other things would have to have happened for it to be false in this instance. That's better, stronger evidence, other things being equal. That's the way I would think about it. But I would bracket this idea that in order to apply to law, it has to match its uses in those contexts. And the response could be, well, then you're not really talking about safety. Maybe not. Going back to the Lown discussion, maybe the response is you're not really talking about inference to the best explanation. Maybe not. It's that complexity, I think, that we have to recognize that there may be a mismatch between these different contexts, and we can still get some possible insight by looking at the features that do apply.
Perfect, thank you. Bueno, acordamos a...
Right, we agreed that questions could also be asked in Spanish by raising your hand in the app. In that case, we can give you the hand, and the professor will be able to use his headsets.
Question from the public. Is there some kind of similarity or relation between safety and the Bayesian likelihood ratio?
There is, but I haven't thought this through completely. I don't know if I can give a really coherent response to this question. They're not the same. I think the likelihood ratio idea can tell us something about the probability of the evidence if this fact were true, and vice versa, versus it's not true. But safety is less about that contrast and more about kind of the world of close possibilities and sort of how easily it could be false. That doesn't quite map onto that. I'll have to give that some more thought, though.
Thank you. Well, what role can lawyers play in the most abstract discussion of epistemic theories?
I think they can play several different roles. I think one important role is to bring the sort of local knowledge that they have of the complex details of legal systems and particular legal cases. I think so one of the main lessons or one of the main points I was trying to make is that to apply abstract philosophical ideas in order to enlighten legal proof, you have to know a lot about the underlying details of how cases work and how reasoning works and those sort of details, and that knowledge is necessary. And so that's a reason for kind of more collaboration between practicing lawyers and philosophers and legal scholars to talk about how these different facts and different ideas may interact with one another.
Thank you. Another question of mine about teaching evidence. Okay. This is a very interesting thing. In the US, as I can understand, you always teach evidence as a different subject.
Yes.
Comparing to civil procedure or criminal procedure. In civil law countries, we were talking about this before the meeting today that with Professor Allen, that civil law countries have rediscovered the importance of evidence as a field, but we teach evidence within the criminal procedure courses or civil procedure courses. Could you please give a comment on this? What do you think? Why separate or why together?
That's a really great question. I think there are advantages and disadvantages to each approach. So one of the challenges in teaching evidence as a separate subject in the United States is that it's sort of trans-substantive, meaning it applies to different subject matter areas, criminal law, civil law, and you have to sort of know something about the substantive law that you're applying evidence law to, and that can be a challenge if students don't all have the same kind of background or sort of understanding. It also means that your discussion is often very surface level in terms of the substantive law that the evidence law is being applied to. And so I could imagine if evidence is taught as part of a particular class in criminal law or civil law subject matters, you can sort of see more closely how the substantive issues and the procedural and evidence issues sort of fit together. I think that can be a really illuminating way to do it.
Thank you very much. Well, now we have an oral question from Professor Jordi Ferrer.
Muchas gracias.
Thank you. Thank you, Mike. Thank you, Mike. I would like to take advantage of this opportunity to say to you all that you can raise your hand using the app, and anyone can send their written questions as well. That way we can establish a more agile conversational discussion. So Mike, thank you so much for your presentation. I really enjoyed it. I would like to ask you a question with a preliminary excuse, if I may. The excuse is that I had to leave the room with the authorities, and maybe you said something that I missed, okay? But in relation to the theory of Larry Lorden, I would like to ask you about something that Larry was concerned about. He was obsessed about it, I would dare to say. That is the relationship between the standard of proof and the asymmetric rules. The asymmetric procedural rules. Larry used to say, if the standards of proof play the role of distributing error, assigning error, I have some problem with that, but you mentioned it as well anyway in your presentation. We have some problems in knowing how to assign or distribute error, right? I would rather refer to the distribution of risk and not the exact distribution of error. But he used to say that if the standard of proof have the goal of distributing or assigning error, then we should not have asymmetric procedural rules that in turn have an impact on the assignment of error in such a way that they alter the political decision made of assigning the error through the standard of proof. So he proposed to remove or get rid of any asymmetric rule. Without asymmetric rules with respect to resources, without asymmetric rules with respect to the exclusion of proof for one party or the other. I believe that this makes all the sense in the world from the point of view of the architecture, epistemological architecture, but it does put some serious problems when it comes to procedural guarantees and rights. So what's your view on that?
So thank you very much for that question. Let me start by saying I agree with your sort of initial comment that I think it makes more sense to talk about risk of error, sort of ex ante, rather than a specific ratio of errors ex post. I feel like trying to produce that after the fact strikes me as impossible, but we can still, in the absence of that knowledge, talk about the risk of error at the front end. So my intuition is the same with yours as a starting point. In my view, I think it's an interesting philosophical exercise to try, as I mentioned, to reduce allocating the risk of error only in the standard of proof and nowhere else. I think it's impossible. I think that would be an impossible project to carry out, even if we're talking about the risk of error rather than producing a set of errors. It's impossible because even if we start talking about evidence rules that we want to change, constitutional rights we want to get rid of, even resources to begin with, there's still going to be asymmetries everywhere. Certain kinds of cases are going to have evidence readily available, other kinds of cases are not. Some kinds of cases are able to produce forensic evidence, for example, which may favor the prosecution. Sort of trying to go through a system and completely get rid of asymmetry just strikes me as a kind of a fool's errand. And so I think it makes more sense to talk about, if we're going to talk about errors and we're going to talk about risks, to do so with the system as a whole. The standard of proof is one component, but really every rule, every practice, every procedure might be allocating the risk of error in some way. And so that's why we should talk about systems rather than one particular rule. Those are my views, at least.
Muy bien.
Very well, thank you. Thank you, Professor Jordi. Thank you, Professor Michele. Now, I would like to give the floor, apologies, I don't know how to pronounce this name, Bart Verheet?
Thank you for a nice talk. I learned many things, Michael. So one of the hopes for me to be interested in epistemology is also that it helps us to do things right, to solve complex cases, to help us find.
I'm sorry, I'm having trouble hearing. I'm sorry, I'm having trouble hearing you. Can you speak up a little bit?
Should I speak louder? Is this better?
Yes, louder. Yeah.
Like this?
Yeah, that's good.
Okay.
I can hear it through here.
Does epistemology help solve hard cases? So the process of justification, yes. Also the process of discovery.
Does it solve hard cases?
Help solve.
Yes,
help.
yeah. I mean, I think it helps solve hard cases and easy cases. I don't think it solves any cases. I think it's a set of tools that may provide helpful ways to think about the various parts of the legal proof process. Maybe it gives us some tools to sort of make explicit what may be implicitly going on, but we didn't have a way to talk about or visualize or think about. And being able to make that explicit may help us sort of see what's going on and give us ways to argue and potentially improve what's happening. But I think it's a sort of open question whether that will help or hurt in any given case. I think of it that way, as sort of a set of tools to make explicit what may be implicit in what we're doing or what a legal system is doing, and that may help. I don't think it necessarily will solve problems. I don't think we can take a philosophical idea or concept and say, this is a great concept, this will tell us how to resolve these hard cases, or even these easy cases for that matter.
Thank you. Okay, now I'm going to read another question here. What role does the idea of possible words on or commitment to them play in discussing epistemic concepts such as safety and sensitivity? What if I do not share their heuristic power or theoretical legitimacy? How could a lawyer approach such sophisticated devices?
Yeah, good. That's a great question. So the starting point, I think, is to go back to the picture that I started with and say, here are some facts about legal proof. And if we start with a fact about legal proof, that the proof process is structured around competing explanations offered by the parties, competing explanations that help explain the events that we're talking about and the evidence that we're seeing. Now we have a set of possibilities to some extent. Now let's introduce some philosophical idea like safety. And here's, again, where the mismatch between philosophy and law may be helpful or worth pointing out. In philosophy, it could be, as I said, sort of tricky and contested and difficult to figure out which possible worlds we're going to look at. Maybe you think that idea itself, as the question mentioned, isn't very helpful or theoretically legitimate. What we have in the proof process already, though, is a set of possible explanations. And we can think of those explanations as, in some sense, the possible worlds that we're considering. Right? This may be not what philosophers would think of or say is sort of a legitimate use of that concept, but in some ways the system has already produced the set of possibilities. Now, we can take this idea, right? How easily could this belief or this piece of evidence or this verdict be false, even if we get it true in this instance? We can start asking that question about the different possible explanations. Right? If one explanation is the defendant committed this crime, and the alternative explanation is either someone else committed the crime or the police framed the defendant, we can ask with these different explanations, given this evidence, right, how easily could one of these be true or the alternative be true? If it could easily be either, right, that tells us something about the evidence, that it has sort of lower probative value in that sense. If, on the other hand, the alternative couldn't easily be true, right? That tells us something about those different possible explanations. And so we've taken this idea and sort of taken it out of its philosophical construct and say, even if you don't buy, as a general matter, this possible worlds idea, the legal system has already forced a sort of set of the possible worlds to begin with. And so that's where I see a possible connection, right? You can take that idea and just impose that on the explanations, and it just gives us one tool to make explicit one aspect of what's going on in that process.
Thank you. Florencia Rimoldi quiere hacer una pregunta.
Florencia would like to ask a question. She's there at the back of the room. Microphone, please.
¿La hago en español?
Should I ask the question in Spanish? Yes. I would like to consider something that was made explicit. No, wait a minute. I'll wait a minute. Is it working now? Yes, it is. Yes. I'll repeat. Yes, please do. Sure. I would like to resume. Oh, could you please stand so that we can see you better? Thank you very much. Right. Now you can see me. I would like to resume or ask you to tell us something about something that you removed from your presentation, which is the relationship or the consequences that can be drawn from legal procedures regarding epistemology, and to establish a relationship of this with some examples or the mismatches. No? No? He's losing? He's losing?
Yeah, if you prefer, yeah.
No, I mean, if there's something wrong with the...
I'm getting static in the...
El profesor está con estática. Si puede hacer en inglés,
Sure.
mejor. Sí.
Yes. So, you explicitly said that you are going to leave aside from this discussion the opposite direction from law to epistemology.
Yes, yes.
But some of the examples you mentioned about the mismatch between theoretical tools and practice,
Yeah.
one can also use them to think that those are not good theories in epistemology. So precision, for instance, or thinking that knowledge implies sensitivity and the like.
Yeah.
So I was wondering if you accept that possible reading. Thank you.
Yes, thank you for that question. So I definitely accept that possible reading. I don't have any particular views on whether that mismatch would be enlightening for particular philosophical reasons, but that's certainly a possibility.
Well, now it's time for a question from someone I think you know. I'm a great fan of him.
Okay.
And I think you are too. So, Professor Ronald J. Allen, please. Okay.
Actually, I was trying to send a question to you, and I don't know, rather than speak at the microphone, and I don't think any of us know how to do that.
We'd like to hear your voice, Professor.
Well, thank you very much, but I'm serious about this. How do we send a message to you all to be asked of him?
Yeah. Through the app, you can send, yeah.
Through the same way? Okay.
Yeah.
Well,
if you prefer that I read, no problem, but
No,
we would like to.
It's fine. Well, in any event, my message that I wanted you to read to him said, "Great job, Mike. Congratulations." You might want to elaborate on the different meaning in the word theory, in what you and I might call naturalized epistemology or our kind of science, and formal epistemology. Like, we're not dealing with something like the general theory of relativity, where if the light doesn't bend around the sun, it's disproven. We're dealing with a set of complex interacting processes that adapt to each other and so on. And the word theory, in the way we use it, is not like the general theory of relativity or gravity or whatever.
Yeah, so not surprisingly, I agree with that. So when I talk about specifically the relative plausibility theory that Ron and I have defended, To call it a theory, we just mean a general explanation of the structure of the proof process and how it works in the United States. In particular, this idea that standards of proof can best be understood as imposing explanatory thresholds, but that this idea about competing explanations explains not only standards of proof, but sort of all features of the proof process. And for that reason, I refer to it as just basically a fact, as a sort of true description of the way that legal proof works as a general matter. There may be kind of small features or cases that are inconsistent with that. That doesn't necessarily sort of falsify the theory. It's just a better explanation at the kind of meta level. It's a better explanation than the other explanations that have been offered to try to explain the same phenomena. Those other explanations are typically different kinds of probability theories, either subjective or objective. Given those competing theories or explanations, the relative plausibility account does a better job explaining the underlying legal reality.
Thank you. Ahora le damos la palabra.
Okay, now we've got Frank Osorio. He's over there. Frank Osorio, please stand up. Great.
I have a quick question. Based on the idea that the jury, of course, they are not lawyers, and it's difficult to deal with these concepts about epistemology, legal proof, evidence, standard of proof. Thinking in a practical measure, it will be possible that the jury could be trained beforehand, even before the jury selection, on those concepts in order to improve the level of rationality or the level of analysis of the evidence, trying to reduce the errors in this adversarial American system? Thank you.
So that's a great question, and it's a complex empirical question. I think whether any particular alteration of jury instructions might improve the rationality or the accuracy of what jurors or juries already do. I think it's certainly possible that introducing certain kinds of ideas might improve fact-finding, but I'm also kind of weary and skeptical of trying to tinker with jury instructions that, in my view, do seem to work pretty well, or at least a process that seems to work pretty well. I do think there's, sort of related to some of the ideas I talked about, I do think there's a potential problem in that what the preponderance standard does is it sort of picks up on natural reasoning tendencies. In the absence of any standard of proof, what a jury is likely to do is something like the preponderance standard anyway, which is pick the best explanation or the better explanation of those advanced in some way. Where there might be a potential room for improvement is with higher standards of proof, clear and convincing evidence, or beyond a reasonable doubt, sort of instructing juries to push jurors away from what might be a natural reasoning tendency, right? Not necessarily to try to develop the best explanation, but to say, even if this explanation is worse than the prosecution's, it's still good enough to raise a reasonable doubt. So what that might do is pick up on some of this reality that what jurors are doing anyway is evaluating competing explanations. Maybe making that more explicit will improve the process, but again, I think that's a really complex empirical question that would need to be studied. But thank you.
Okay, now a question from Professor Hermes Zanetti Jr. from Brazil. I don't know, Professor Hermes, if you'd like to, se gostaria de fazer a pergunta oralmente. Não estou vendo, professor Hermes.
I don't know if you want to ask. I can't see Professor here. Then
as explained, jurors are considered rational because they are expected to provide reasons to one another and engage in deliberation. Trust is the verdict that arises from this collective reasoning process. But how does this hold in countries like Brazil, within the civil law tradition, where jurors do not deliberate in the same way as in common law systems?
I'm going to plead ignorance on that question. I don't know. I don't know much about the legal system in Brazil to give an opinion on jury reasoning in the absence of that kind of deliberation.
Perfect. Thank you. Question. Okay.
Vitor, acá.
Isto aqui? Thank you.
Okay.
Just to clarify the question, Professor, just to clarify the question about the Brazilian system.
Can you hear him? He's talking in English.
I can hear it now. Yeah.
Hermes?
Yes.
Just to clarify the question, in Brazil, we do not deliberate. The jurors just decide in isolated form, just voting yes or no about questions previous assigned to them. That's the point.
Yes.
There is no deliberation at all.
Yeah, that's a great, not only question, but kind of interesting contrast, and I haven't thought it through. I'm just sort of thinking it through right now for the first time. Again, I think it would be an interesting empirical study to see if you can sort of tease out the difference that makes and what effect that might have on accuracy in some sense. I think a lot of the empirical literature on juries in the United States suggests that it's the individual jurors' interaction with the evidence that predicts a lot of outcomes, more so than deliberation. I think that's a really interesting contrast.
Thank you. Maria Inés Horowitz tiene
Yeah, Ines Horowitz, she's here, third row. Could you please stand up?
Ahora arreglamos el tema de la traducción, así que si prefiere.
And we should have fixed the translation thing. You can speak in Spanish if you want. Spanish is okay, yes. You can ask in English. It's should work. Okay, so Professor Pardo, there's something I'm quite concerned about for some time, which is the importation of the American model to our countries in which we don't have the same system. Of course, we don't have common law, but civil law, and this is particularly important and significant in criminal law. Taruffo was quite critic with the American system because he thought it didn't seek the truth, but competition between adversaries and the dextership and the skills of lawyers is what matters. So the best narration, you're talking about disputing explanation, and of course the parties want to win and not they don't really care about the truth. So in our systems, at least in theory, truth is indeed very important. The truth of the factual claims on the accusation. So to what extent, let's say, epistemology in the US is rather a challenge, as you suggest, because in practice, how can you assess the system works in the field of criminal law? You know, actually seeking the truth and the importance of epistemology, of knowledge. So how to confront this issue with the fact that lawyers don't really seek the truth, but they want to win, right?
Sorry. Thank you for that question. That's a great, really hard question. Again, I'm not qualified to speak on the kind of superiority or the sort of the details of other legal systems. I have to say I'm a little bit ambivalent about the adversarial system in the United States. For better or worse, there does seem to be an assumption, and the assumption is that the adversarial clash between the parties will be the best way of both uncovering evidence and arriving at truth. There's lots of reasons why that fails in individual cases, and it's not clear how sort of tinkering with that would necessarily improve or not improve it. I'm sort of taking a different methodological approach at least in this talk and in thinking about the applications of epistemology, and that I'm taking the system as I find it. I'm sort of taking the way legal proof works in the United States, which, as I described, is very heavily dependent on the adversarial system to not only produce evidence, but produce explanations, with this assumption that that process will produce results that will track the truth in some way. That may be false. There may be other ways to improve that process. But I think, at least my starting point is that there's still a lot to learn about how the proof process is working, and I see epistemology as sort of helping us learn what's happening on the ground, which I think is important as a prerequisite to make any kind of change or make any kind of reform. But I'm not necessarily a champion of the adversarial system, nor do I think it's the only or the best way to arrive at truth. I think there's sort of many different ways of organizing a legal proof process. The main lesson that I would have is that, or the main lesson I would want to convey is that in order to understand the success of that system of legal proof, you have to look at the system as a whole and how the different parts, including the different actors, work together, and then study that rather than try to take some piece out of that system, like a standard of proof or probative value or whatever, and sort of think that we can sort of do all the work just by looking at that component part.
Thank you very much, Professor. Ahora le damos la palabra.
Okay, now Edgar Aguilera has the floor. He also wanted to ask a question. Professor Edgar Aguilera, if you could get the microphone to him.
Thank you, Michael, for that wonderful lecture. And I wanted to point out two things very briefly. One is that whether you think that explanatory considerations may have an impact or may be put to use also at the micro level of the analysis of evidential reasoning. What would be that way to put to use the idea of explanatory considerations at the micro level? And the other one has to do with, if I understood you correctly, in a previous example you gave, you said that one of the restrictions within the US evidential law regime, basically triers of fact have to consider only the stories put forward by the parties. But I understand that you and Ron take the criminal standard of proof cashed out in terms of explanatory considerations as being the only plausible explanation available for the evidence. But that, to me, it seems that you need to consider alternative stories compatible with the innocence of the accused that may or may not have been put forward by the other party. And I think there's a tension between what you said. But just those 2 points. Thank you.
Yeah, thank you very much for those two questions. I'll take them in order. So at the micro level, we can ask, how can explanatory considerations tell us something about, say, relevance or probative value? If we have a set of competing explanations, one thing that those explanations will help structure is which evidence is relevant and the strength of that evidence in supporting or challenging those particular explanations. Now, why does this provide some kind of insight? One thing it gives some insight to is how, say, the concept of relevance works in the United States. Right? The alternative models are something like probability models that make evidence relevant only if it changes the probability in a particular direction. But what we find, if you look at actual cases, is that evidence might be relevant because it challenges or supports a particular explanation, and indeed it might be part of both sides' explanations. In other words, it sort of overlaps. It's the kind of evidence that to be true or to be successful, either party must be able to explain. It doesn't necessarily discriminate probabilistically, right? So it's a different kind of explanation for why evidence is relevant. And what makes it relevant is the role that it's playing in this larger explanatory system. We can ask that same question about probative value. We can say, if probative value can't be quantified, and there's sort of lots of reasons to think it can't be quantified in the United States, how do we get some sense of when the probative value is strong or weak or kind of medium? Again, we can ask the role that it plays in supporting or challenging different explanations. Again, it's not very precise, but again, going back to my talk, you have this sort of illusion of precision that may be going on. It may not be possible to precisely quantify probative value. And so one kind of virtue of an explanatory approach is that it picks up on this sort of fuzzy feature of sort of what's going on with probative value. Turning to the second question, I should clarify a couple of details, right? So fact finders do not have to consider explanations not offered by the parties. They may do so. They sort of have the power to say, we think this is what happened and it's different from what the parties had done. There's nothing to stop often fact finders from doing that, but they're not required to consider explanations not offered by the parties. Now think about how that maps on to the beyond a reasonable doubt standard as Ron and I have articulated it. There's sort of two reasons why a jury should not convict under that standard, right? One is they don't think the prosecution's explanation is strong enough, right? There just may be reasons why you don't think it's not only plausible, but not sort of strong enough. There may be defects in the theory, and that may be a defense on its own. Alternatively, a defendant may give a plausible alternative. They may give a plausible alternative, and that may be sufficient to raise a reasonable doubt. And there are cases, even though the defendant's not required to offer an alternative, there are cases evaluating sufficiency of evidence that will say once the prosecution has offered a convincing, sort of strong explanation, there needs to be a plausible alternative, or just as a matter of fact, juries will convict and the evidence will be held to be sufficient. So you have these sort of two different ways we might approach that standard. So defendants are not required to provide an alternative, but given the practical realities of a trial, an alternative may be necessary in order to raise a reasonable doubt. But again, you'd have to look at the context of the particular case details to know which of those two situations you were in.
Thank you, Professor Pardo.
Now, let's give the floor to Jaime Oportes.
My question is, what do you think about the need to know the underlying philosophical theories in epistemology in order to formulate accurate criticism of certain positions in epistemological theories directed at law? For example, it seems to me that the notion of knowledge used by Sarah Moss in her paper doesn't follow the idea of a conjunctive conception of knowledge as presented at the end of the paper. Thank you.
So thank you for that question. As I understand the question is about to what extent do you have to know or understand the philosophical details in order to assess whether or not that theory can shed some light on legal proof in some sense. Just as I think you need to know enough of the legal details to know if you're accurately describing what it is you're trying to illuminate, I think you also have to know enough of the philosophical details to know how it's being applied or not in a particular context. I think from the perspective that I'm taking, the thing that you have to know is whether or not these ideas are illuminating or accurately describing the reality that they're describing. In my example, it was the preponderance of the evidence standard, right? And I took the Moss example to say, here's a theory of, or here's an explanation of preponderance of the evidence. It's using philosophy as a way to explain what the preponderance of the evidence standard is, how it operates in the law. And so what I've taken is that description and say, here's where it doesn't match the underlying legal details. Now, you can sort of respond, I think, to me by saying, no, I've got the underlying legal details wrong, or I've got the philosophical details in my description, right? Maybe you think I've done one or the other, but that's the sort of methodological move I'm making, is saying, here's a description philosophically that's meant to tell us something about legal reality, and I see a disconnect or an inconsistency, right? And now maybe this is a good philosophical theory, and I'm very sympathetic to the theory and Moss's work generally, but I see this disconnect here and saying that that's not a good explanation for the preponderance standard because there are underlying details about how preponderance works that don't match the philosophical description.
Thank you, Professor Pardo. Now, Professor David Feigman wants, yeah, there, please.
Thank you. Mike, I really enjoyed your talk. The question I have is, when you are talking about standards of proof, and you're talking about allocating error, to what extent should judges, at least in the American system, take into account the external impacts of error? So, for example, in Daubert, Merrell Dow Pharmaceuticals took Bendectin off the market. Turned out that Bendectin was safe and was back on the market 10 years later. In the silicone implant litigation, the implants were taken off the market. Turned out they were safe and they were back on the market. Monsanto and Roundup. And so when you're considering the question in the individual case of allocating error, to what extent are societal errors part of that equation?
Yeah, so that's a great question. Thank you for that. So, at least in theory, and maybe you disagree with this, judges should not be deciding how to allocate the risk of error in setting a standard of proof, right? Supposedly, the burden of proof and standard of proof have done that generally. And the Supreme Court has been pretty clear about that. It's saying, sort of as a matter of procedural due process, judges can't, in individual cases, sort of adjust the standard of proof, right? Just as a matter of kind of general doctrine. The standard of proof is the standard of proof, say it's preponderance of the evidence. But judges in individual cases now have to decide whether the evidence is sufficient or not to meet the preponderance of the evidence standard. As I've discussed, and maybe you agree or disagree, preponderance of the evidence can be sort of vague, it can be sort of ambiguous, right? And so when judges now have to assess whether a reasonable jury could find this fact by a preponderance of the evidence, do those considerations come into play? Should they come into play? I take that to be the sort of import maybe of your question. And I'm not sure. I'm not sure what to do in that situation. I think what often happens, as you probably know more than anyone, is that that question gets decided at the level of admissibility. It gets admitted at the level of admissibility of expert testimony. And at that stage, I think there may be sort of broader considerations like those you're commenting on come into play. You may know more about that than I do. But that, I think, is really a problem to some extent with the United States approach to expert testimony, and that we give judges this power to do admissibility decisions when what they really may be doing are sufficiency determinations in the guise of admissibility determinations. But to sort of go back to where I started, I think the standard of proof is the standard of proof, and judges on an individual basis should not be altering that as a matter of doctrine.
Thank you. Now, Professor Paul Roberts, please.
Buenos dias. Thanks, Mike. Great talk. Wonderful start to what's going to be a magnificent conference, I'm sure. We'll have a great week here. I'm going to disappoint your final remark because I'm not going to disagree with you. I think what you said makes perfect sense to me. The core of the thesis really is that, yes, we can learn from philosophical tools, we can make use of them, but they need to be adapted. We can't just take them, off the peg. We need bespoke tailoring for our theoretical tools when we come to law and to what I would call jurisprudential questions. I completely agree with that. However, that kind of claim will typically evoke a measure of skepticism, particularly from people who would regard themselves as not theorists, right? Evidence teachers, evidence scholars. They want some practical illustration of how this will work. And some of that's come out from some of the more recent questions that we've had. But I'd like to invite you, please, if I may, to comment a bit more on how you use this kind of material in your teaching. Because what I'm curious about is whether a transubstantive model of the federal rules of evidence, what I might call the tyranny of the federal rules of evidence, maybe you recognize that, maybe you don't. Does that allow you to bring this material into your teaching so that you can show your students why they should care about epistemology and not just about what a judge said in the last case? Thanks.
Thanks, Paul. I appreciate the question. And thank you for agreeing. So I'm fortunate enough when I teach evidence that I get to teach two different evidence courses. I teach a basic evidence course that's basically teaching the federal rules of evidence, the tyranny of the federal rules of evidence, as you described it. And then I teach an advanced evidence course, and the advanced evidence course allows me to do more kind of in-depth look, not only at particular kinds of problems and cases, but also can bring in more of this theoretical kind of stuff. And so that gives me an opportunity to talk a little bit about things like inference to the best explanation. Although even in the evidence course, I do basic evidence course, federal rules of evidence. We spend time talking about things like relevance and things like probative value and what that means and what preponderance of the evidence means and what beyond a reasonable doubt means. And just those concepts being so vague and ambiguous invite these kinds of ideas. And one of the things I'm trying to draw attention to both in this talk and in my work is this idea of kind of making explicit what's already implicit in our practices, right? And so when my students and I are arguing about whether some evidence is relevant or not, or whether it's probative or not, or whether it meets the preponderance standard, you can help sort of make explicit ideas that are already implicit in the reasoning that judges and lawyers are already doing, right? And you can see it too in case law, right? You see it in even United States Supreme Court will decide cases and say, a party has to prove this by a preponderance of the evidence, and immediately they'll start talking about here's the explanation and here's the alternative explanation, right? And so these kind of ideas give us a vocabulary for talking about the kind of reasoning that's already going on. I think just from my own experience and talking to experienced lawyers that a lot of the literature about explanations and competing explanations makes perfect sense and sort of describes a lot of what sort of happens already in a trial process. And so I sort of use those details as a way to kind of make some of these ideas more explicit, right? Ideas like even the knowledge point, this gap between justification and truth, and whether or not you have a successful verdict. If you have both of those without the appropriate connection, I think that's an intuitive point, but you need the philosophy aspect of it to help kind of make explicit what's going on intuitively. Similarly, even the blue bus problem, right? I teach those hypotheticals in my advanced evidence class, and we sort of start with those and try to make explicit what the intuitions are and why, and eventually we get to the conclusion that, well, maybe probative value is not the number, and maybe the standard of proof is not this probability threshold, and if that's true, then we've sort of dissolved the problem. People disagree. People in this room, I'm sure, disagree with what I just said, but that gives us a way to sort of talk about these recurring issues.
Bueno, tendremos una última.
Well, we've got time for one last question. We've got Christian Puebla. So let's agree on this last question, but a very short one because we just have 1 minute for the question and the answer before the break.
For your presentation, Professor Pardo, was an excellent job. And I think the euros are reasonable too, but my question is about how is it possible introduce credential epistemic in the voir dire for one side and in the instructions specifically. Thank you.
I'm sorry, I had a little trouble hearing that question. Can we?
Can you repeat, please?
Can you? I'm sorry.
No problem. How is it possible introduce epistemic credentials in instructions and in the voir dire moment of the euros system? Can be clear?
I think I got the question right.
Okay, my English is not the
No, your English is fine. I'm hearing some feedback, so it's sometimes hard to hear without the headphones. So I take the question to be how to introduce the epistemic criteria into either the instructions given to juries or the reasoning of judges or juries about the evidence. I think I'm somewhat cautious of tinkering with instructions. I think it could be possible to explain some of these ideas in a way to try to make explicit some of the decision-making that's going on. I mentioned explanations as a possible example, but we could think about some of the other ideas as well, right? We could say, if we think it's helpful, something about safety or sensitivity, how easily could you have this evidence and this be false? Or if it were false, would you still have this evidence? You could ask those sort of questions. Now, lawyers are already asking those questions as part of the process. Putting them specifically in instructions may or may not help that process. I think that's an empirical question that would have to be studied. I think you see these ideas come up in judicial reasoning. Usually they're more sort of implicit, and what the philosophical vocabulary might do is help to make explicit some of the reasoning that's already going on, or it gives some tools for giving additional reasons in particular directions. Those would be my sort of initial thoughts.
Thank you, Professor Pardo.
Okay, thank you, Professor Pardo. Thank you, everyone, again. And thank you, Professor Pardo. And now everyone is invited to a coffee break, which will be just in front of the main doors. And with this, we close this first session. Thank you very much.